Hello, everyone. Thank you so much for joining us here today for our webinar on the initial report of the WIPO ICA UDRP review project team. It is a joint effort brought together voices from across the domain name and IP communities, and I am thrilled to welcome our two hosts for today and the two co-leads of the report, Brian Beckham, WIPO's head of Internet Dispute Resolution Section, and Zak Muscovitch, ICA's General Counsel. Brian, maybe we can start with you. WIPO just recently had a conference in Geneva, UDRP's 25th anniversary. Maybe you can tell us a little bit about it.
Thanks again for inviting us. We, at the end of April, which feels like many months ago, had an event to celebrate 25 years of managing the EDRP at WIPO. It was a huge success. I'm still getting LinkedIn updates from people posting photos, and so overall, it was better than expected.
Yeah, I checked today, 25, I guess it's even 26 years technically since the UDRP was enacted by ICANN. And I checked back and I saw that back in 1999, Bill Clinton was president and the Backstreet Boys had one of the number one songs. So it's been a while, but it's worked out very well, having adjudicated about 120,000 cases. Maybe you could tell us a little bit about briefly the origins of the UDRP and where things stand now.
Yeah, good. So, since we're recorded, I won't put you on the spot and ask you to sing the song that was in the top of the charts. But
Yeah.
I'd be willing to bet that the Backstreet Boys might have filed a case over the years. So yeah, well, one of the things that we actually touched upon at our conference, and apologies if this is a small repeat snippet for some of those that were in attendance, and I see a number of familiar names in the room, and also a number of new names. But basically, back in the mid 90s, the domain name system and the internet were largely unregulated. People called it the Wild West, and one of the things that we highlighted in our conference was an article in Wired magazine where a reporter registered McDonald's.com. And long story short, he was able to do that without any restrictions, and wrote about it. And I think that really shone a spotlight on the issue. And so a number of governments, notably the United States government, asked the WIPO Secretariat to look into this problem of cyber squatting, it was called, and come up with a solution. And the focus of the process that WIPO undertook was on trademarks. And there were 18 consultations in many cities around the world. A draft report was produced, public comments were solicited, a final report was produced, and in that report was the blueprint for the UDRP. So just a couple of kind of key highlights are that because this was really uncharted territory, there was a decision that this should be an administrative contractual process, not an arbitration process. And then parties would always retain the option to go to court. It was implemented directly by the registrar. There was a series of high-level criteria that had to be satisfied. There were some illustrative examples on how to prove bad faith or rights for legitimate interest by way of defense. But basically, the report was produced. It was handed over to ICANN, which was then newly formed, to what was the precursor to its generic name supporting organization council, the DNSO. And a working group took the WIPO report, made a few adjustments, and it was plugged in as ICANN's first consensus policy in the end of 1999. The first case was filed at the end of that year, and it was off to the races since then.
Right, right. So that's a great context for where we're at now, because where we're at now is after 26 years, even great policies and ICANN's UDRP is arguably one of its showcase policies, and it's lasted the test of time. But even great policies need to be reviewed, just like the Backstreet Boys music does after 26 years. And so ICANN has undertaken a review process that was broken up into phase one and phase two. And phase one which I don't remember the exact dates, so I'm just going with like pre-COVID, approximately. That phase one dealt primarily with the URS and with the Trademark Clearinghouse, and phase two is going to tackle the UDRP. But maybe just say a few words about where things are at, just technically speaking, from the ICANN governance perspective.
Yeah, sure. So right in the early days, there were a few questions that came up, and there was actually an early effort to look at the UDRP and see whether there ought to be some changes made. And in the end, the decision was to leave it as is. Then I believe it was 2008 and 9, we actually proposed to ICANN, WIPO, that is, to transition the UDRP from a paper-based process to a primarily paperless process. So in the beginning 10 years of the UDRP, parties were required to send 5 copies of their complaint and all of the annexes to a provider. The provider then had to send that out to the registrant, and it was relatively cumbersome for a process that was dealing with domain names and online behavior. So ICANN's board of directors accepted to change the UDRP rules to make it effectively paperless. There's a small safety valve where the providers still send a written document which notifies a party that a case has been filed against them and informs them how to access that over email. And then I believe it was 2011, there was another kind of effort or a question whether the UDRP ought to be reviewed. And ICANN conducted a series of consultations. And the upshot of that was, on one hand, because new GTLDs were coming and there was concerns that there was just too many moving pieces. And on the other hand, the UDRP seemed to be working well, and there was no burning need to review that with new GTLDs on the horizon. So it was decided to park that for the time being. And the decision was that for rights protection mechanisms that were created specifically for new GTLDs. So here we have the Uniform Rapid Suspension, which is sort of a lighter version of the UDRP, which applies only to new GTLDs, and things like trademark claims and notices, which hang off of the back of the Trademark Clearinghouse. So the decision was, once we get new GTLDs behind us, let's take a look at those mechanisms that were created to address the concerns about this new flood of internet domain names. And then once we do that, we'll see if we want to take a look at the UDRP. So that brings us full circle to where we are today. As you and others will know, we spent about 4.5 years looking at the first set of recommendations that were recommended for new GTLDs. And without belaboring the point, it was a complicated process, and ultimately not a lot of changes came out on the end of that process. And the main takeaway from the community, particularly the participants, the ICANN staff, was, yes, there's been a decision by the council to review the UDRP as a second phase of the rights protection review, but we all wish to do it in a more efficient way. And so that really takes us to the idea that brought ICA and WIPO together. We thought, look, here's 2 organizations that have a big stake in the good functioning and good health of the UDRP. Why don't we convene a group of experts to see if there are areas where there's consensus possible, if there are areas where there's not consensus possible. And so that was, I suppose, about 2 years ago, we kind of birthed the idea of doing this really to assist ICANN and the ICANN community in its process. We, as Zak, you know very well, and for people that are listening, we're very much aware that ICANN has its processes built into its its bylaws and operating processes. But we thought, why don't we see if we can't help that be done more efficiently? And one of the main areas that we've sought to do that is in the chartering. So in the charter for the first process, and I think it's widely recognized that this is one of the reasons why the first phase of the RPM review took so long and was so complicated, was that the charter was basically an open call for comments that was never curated. And so there was a lot of overlap and kind of, tension between ideas that were thrown out by the community in terms of the topics that should be discussed. And so we thought, why don't we see if we can't help inform the charter to really narrow the scope of the work for the UDRP to make the most impact.
Yeah, very well said. So let me add a little bit of my own thoughts. That is that the phase one was, as you mentioned, about 4.5 years, and arguably the topics that it took on, URS and trademark claims house related matters, are less complicated, if I could put it that way, than the UDRP. And so if there were to be a phase two, the people that exited from the phase one, many of them were like, well, listen, if that took 4.5 years, imagine how long a phase two UDRP review could take. And there's many issues that are of importance to various people depending on the perspective with the UDRP. And so people sat back and say, well, gosh, is there a better way of doing this? Can we determine by consulting people who have practical experience over 26 years of dealing with the UDRP day in, day out as practitioners, as panelists, as providers, etc. Is there any chance that these people, if we get them in a room, can identify and say, okay, this is where we can agree on some things, and this is where more work is required if there is to be any agreement, and then bring those conclusions to the broader ICANN community and kind of give a bit of a running start, a head start to say, listen, ICANN's got to go through its regular policy development process, no question about that. But in terms of when it's ultimately chartered by the GNSO Council, would the GNSO Council and the broader ICANN community benefit from having heard of people who've been in the trenches for these 26 years, who are, from a very practical perspective, saying, listen, these are the procedural things that we've noticed need to be tweaked. These are the things that we can all agree on. These are the things we can't agree on at this time, and we're going to need to put much more work into those things. And that's really, the impetus for this report that the WIPO and ICA did. And I think by the end of this call, and it's a short call, it's only 1 hour, we won't be able to go through the whole report with you, but hopefully you've gotten a flavor of its context, and you've gotten a bit of a flavor of its reason for being and its impetus, and you'll get a little bit of a flavor of the kinds of recommendations that we're proposing to the ICANN community. And so I'll share my screen, and maybe we could talk a little bit about the makeup of and the consultative process that we undertook. Brian, if you could maybe share a little bit about that.
Yeah, perfect. So it will become apparent to people that read the report. Two things. We wanted to try to be as representative as possible. As you said, Zach, we wanted to get people that are really living and breathing the UDRP in the trenches, as you said. And so we really undertook, an effort to canvass people that are users of the system to really get their input. We had participants who were domain registrants, domain investors, brand owners, counsel for complainants, counsel for respondents, panelists themselves, the lead faculty for our UDRP training workshop. You can see on the screen there the participants in the working group. We were quite conscious of not replicating the kind of not only the stakeholder group formalities of ICANN, but you might notice that a lot of the individuals that are listed there as the project team are not individuals that are actually active in in ICANN circles, and we were quite conscious about that decision. We didn't want to give the appearance that this was somehow trying to sidestep an ICANN process. So we really wanted to, as I say, cover as wide a swath of the community of users of the UDRP as possible, and also not be seen as somehow overstepping ICANN's policy remit here. With that said, as you can see, it's a relatively tight group. And we know that there's a lot of people. If I just look at the participants on this call, for example, I see 85, 86 people signed up for the call. Obviously, with a group of 86, that would make our job all the more difficult. The first working group at ICANN on the first phase of the RPM review had, I think, about 150 members. Not all of them were active participants in every single phone call, but on average, I would say there were probably about 40 or 50 participants on a phone call. And on the one hand, that's great from a kind of democrative perspective, but on the other hand, then that obviously necessarily slows down progress. So we focused on a group that we thought was pretty widely representative of the users of the system as the core project team. But we were, like I say, mindful that there were a lot of other people who also might have inputs into the process. And so what we did was we during the course of a couple of months last summer, we held a series of, I can't remember if it was about 10 or a dozen phone calls where we invited particular subject matter experts. You can see on the screen there. So we invited people who are scholars in the UDRP, CCTLD registries, registrars, brand owners, registrants, non-commercial users, and we wanted to hear from them as well. And they provided valuable input that then the group worked on. We worked on a document where we kind of canvassed all of the views from our project team, from the participants in the series of phone calls. We conducted a survey amongst the group to sort of gauge the temperature on a range of about 25 or 26 topics that you can see there on the screen. And we still recognize that with the kind of two tiers of the project team, we've still not, it's still not possible to cover everyone who has an interest in the good functioning of the UDRP. And so that brought us to the idea of putting our report out for public comment, which is where we find ourselves today, and is really the purpose of this call and the outreach we've been undertaking. We've had a few comments submitted already, but we really would encourage people to read the report. We produced an executive summary, but one or two of the comments that have come in already actually propose recommendations on topics that are already covered in the report. So would really stress if you take a look at the executive summary, if there's a particular topic that you feel strongly about, it's worth going back and looking not only at the summary, but at the report itself to see what were the discussions amongst the project team and why did they land where they did before submitting comments.
Yeah, thank you, Brian. So and even with the project team and the group of experts that were consulted, and we have to thank each and every one of them for dedicating their time as volunteers to the process. Thank you so much. Obviously, couldn't do this without that kind of input. And as Brian mentioned, we're encouraging even broader input from everyone on this call and beyond. And Camila will put into the chat the link for specific feedback. And I want to go back to the report for a moment and talk and just show the issues that we collectively as a group identified as being topics that were worthy of discussion. And you could see them here. Basically, we invited everyone to throw topics into the bucket. And at the end of it, this is the list of principal topics that we came up with. Now, if there's topics that weren't covered, that's exactly where we want to hear from you. But we feel that generally we canvassed the issues that were top of mind to practitioners and panelists as well. Now, from that list, we want to talk a little bit about the general approach that we employed. The first general approach is it was a principle that was identified fairly early on by the project team that we don't want to do anything that will damage or destabilize the UDRP. That was a key consideration. In other words, when you put a room full of lawyers together, they could come up with some very creative solutions, great, brilliant ideas. But at the end of the day, we wanted to make sure that the UDRP isn't destabilized and continues to be of use. And so that was an overarching so-called primary directive throughout the process. The second thing that we tried to do is to identify what you could call low-hanging fruit, where there was unanimity. And so we grouped these topics into two tiers. Tier one, it had unanimity of the project team. And this was a fairly diverse project team. So what you should be able to take from findings of unanimity is a fairly strong signal to the broader ICANN community that if these topics were to come up in a working group, there would be a better than average chance of finding consensus, big C consensus on these topics. And for those who are not directly involved in the ICANN milieu, big C consensus is a term of art. That's what's required in order to move policy proposals and changes through for the UDRP. So to reach consensus is the key of all of this. And so we were able to reach unanimity, which is a signal of potential consensus. The second tier that we looked at was were items that we didn't find agreement on within the group. And I'm just going to quickly scroll to these. Well,
Yeah, and while you're doing that, Zach, I almost couldn't stress enough that kind of guiding principle of do no harm, the UDRP is working well. I was really struck in our very first call with the project team, one or two individuals who have been known to be somewhat strong critics of the UDRP or maybe individual decisions over the years, really put that right front and center for us at the very beginning. I recall one person said, look, I might like to change this or that, but at the end of the day, I'm not going to quibble over these changes if it means upsetting the balance and having to deal with messy, complicated conversations about changing this and the kind of typical horse trading that goes on in policymaking. So that really was our guiding principle. I think it really can't be stressed enough. It's been 25 years. The case numbers continue to rise, which shows that it's still not only a very effective tool, but a very widely used tool. And there was zero appetite whatsoever amongst the project team to undo the work of the UDRP.
That's right, and that does not mean to say, I don't think you mean to say it by any means, Brian, is that there are not changes that can be made, but it's always a matter of gauging the potential benefits of the changes against potential disruption of the changes. And so things can be made better, but they can also be made quite a bit worse. And that's the fear that's kind of in the back of minds of practitioners and panelists alike when it comes to this. And so I mentioned, the tier one unanimity of the project on some issues, and we'll go through some of those momentarily. And tier two, and we color coded as yellow as kind of like a caution. This is where there was some and sometimes considerable appetite for changes that were significant, like an appeals layer, etc., which we'll go through those momentarily, some of them at least. But there wasn't unanimity on how to technically deal with them or the features of these proposals, or somewhere there was just, to use ICANN parlance, divergence about it. And that the ICANN community can take as a signal that should these be included in the charter for phase two, they will likely not easily reach consensus. And therefore, the second overall approach we took was this bifurcation of let's deal with the lower hanging, lower ticket, less controversial, likely to get consensus items in a part one of phase two, if I can put it like that, and defer the second, more complicated, more controversial, more fraught topics into a part two of phase two. And that's, I think this is a key to the approach that we took with this review, is that there needs to be a review. It needs to eventually be done. It's recently been deferred, and there's a lot of competing issues competing for the ICANN community's time, no doubt, with new GTLD round coming out, etc., other policy work that is ongoing. But I think we believe, and Brian, correct me if I'm wrong, indicate if you agree, that we think that by taking this practical, streamlined, bifurcated approach, that the ICANN community need not fear a phase two review commencing, because it'll be able to be dealt with in a much more efficient and targeted and focused manner, while adopting a general approach of doing no harm and deferring the more fraught issues to a second part of phase two.
I think that that's exactly right, and you know, the idea was the first batch of topics were ones, if you see, for example, on your screen, loser pays. This has been a topic that's come up repeatedly over the years. Brand owners have asked for this. The problem is sometimes described as a whack-a-mole problem. The cost to register a domain name are relatively minimal compared to the cost to file a DRP case. And so there's really no disincentive to repeat repeat infringement. In fact, there are a number of parties who come up frequently, and one of the criteria for how to prove bad faith is whether there's a pattern of abuse undertaken by a registrant. So naturally, brand owners said, look, you know, this is a problem that doesn't seem to go away. There's no disincentive for bad actors to keep doing what they're doing and make our lives difficult. And so we would really like to see a system which penalizes them. But the group nonetheless, you know, and we go through this in detail in the report, looked at, you know, what would it look like in practice to actually manage a loser pay system, or to award costs or award damages. And in the end, even the brand owners who had been asking for this agreed that the complications around implementing that concept outweighed the potential benefit of deploying that system in practice. And you know, as you said, we fully recognize that you know, ICANN has its own processes. We hope that the list of topics that we've covered help to inform the charter, and that the recommendations from our project team serve as some sort of a kind of a guidepost for whether it's likely to achieve consensus in an ICANN working group. And the idea is then that it allows, as I think, as you put it, kind of a phase one of phase two and a phase two of phase two, to where you know, to let precisely because you said there's a lot of stuff competing for people's attention. There's another round of new GTLDs coming. There's discussions around you know, different types of domain name abuse and contractual amendments and so on. So you know, privacy and proxy issues, GDPR related issues. So no shortage of topics fighting for people's attention around ICANN. And the idea was really to you know, help whatever working group is formed to look at this, to see where an informed group of stakeholders who live and breathe the UDRP came out on a particular group of topics. Some of them, obviously, people would have liked to see them come out differently, but if we go back to that kind of guidepost of you know, not upsetting the apple cart and not engaging in horse trading and risk upsetting the balance of the UDRP that's been achieved over the years. And I will say, even for the topics in the second kind of grouping, where it wasn't possible to achieve consensus among the project team in the time we had, which was roughly a year working on this, I think go out on a limb and say for a number of those topics, if we had had more time, I feel we probably could have achieved consensus among the project team on those. And so it will be interesting to see what a further ICANN working group does with those.
Indeed. So look, we're going to try to reserve some 15 minutes at the end for some questions, and you're welcome to put questions into the chat, and Camila will help us as Brian and I are paying attention to delivering our comments, not able to look at the chat necessarily at the time, but maybe we could take some time, Brian, just to highlight a few of the tier 1 and a few of the tier 2 recommendations, and some were recommendations for doing something and some were recommendations against doing something. And this is just a summary. If you go into the report, you'll see the rationale, which is a summary of the deliberations that the project team made, and are probably quite representative of the kinds of deliberations a larger working group would make in these matters. And so, I'll just pick out a couple. Maybe you can take out a couple as well to highlight them for the audience. And we have a very significant audience today. Thank you so much for attending. How many people do we have right now, Camila, watching?
We have over 80, 85.
Right. Okay.
Yeah.
Terrific. So I'll just briefly recap on the loser pays. This also encompasses something that's probably the number one issue that I'm asked about by domain name registrants, which is a penalty for RDNH, for reverse domain name hijacking. And even several panelists I've spoken to, have lost patience with bad faith complaints, and they even see a merit in an RDNH penalty. Bearing in mind that RDNH is by far a very small fraction of the number of cases, but still something that is upsetting and for registrants when they have to defend and spend the money in defending against a meritless case. But when we looked at this, and Brian touched upon it, one of the big issues was that, how do you collect, even if there were to be an RDNH penalty, how does one collect it? ICANN is not equipped for it. The providers certainly don't want to get into collection. And so that would mean going to court potentially in a far off jurisdiction to collect, spending more money in court. In fact, my own experiences as a Canadian lawyer, we have penalties for RDNH in the .ca system. There's been, I believe, 2 or 3 cost awards for RDNH. And the successful respondent in those cases has to go and sue to get it. So that was one of the issues. Now, there's more to discuss with this, but on the whole, the project team felt that, even if we were to start asking for deposits from parties, it wouldn't only be complainants who were asked to put in deposits. It would be respondents potentially who could be asked to put in deposits in case the complainant won. And who's going to hold these deposits and who's going to release them? And, it's a whole other layer. And so there's a lot of good reasons to have penalties and cost consequences for reasons of deterrence and justice. But there's also, it creates access to justice issues. It creates administrative complications. It creates additional costs and may not be overall a great improvement. And so that's why the project team reached unanimity on this. But I know it continues to be a topic that's raised by people, and so there should be more discussions about it. But the project team, after mulling it over back and forth this way and that way, we came to the conclusion that although there may be good reasons for it, the reasons against it outweigh it. You'll see that, fee payment deadlines, this is something that only practitioners really and providers would be sensitive to through 26 years of dealing with this. This isn't a big, broad, principled issue. This is just something that we've noticed that there's a bit of a gap in the rules, that there's no fixed timeline for complainants to pay their share of the fees when there's a 3-person panel nominated by the respondent. And it's just a small gap, but it's something that's annoying and has been annoying for a number of years. It's something that can be addressed, and also provides some comfort for providers who now have rules that they can enforce against the filing parties. Pick another one that was very interesting. Well, clarifying registrar verification procedures. You know what? This is a bit of a complicated one, so I just briefly mentions that with the who is verification procedure that we use now, the complainant files provider reviews, uh, provider requests who is verification from the registrar. Registrar provides it to the provider, and we notice that some providers aren't providing the who is verification data to both parties and to the panel, and this is something that practitioners clued in upon. A small discrete issue we thought uh, could be uh, could be solved. Now, here, Brian, maybe you want to pick a few of your favorites, probably bigger items than the ones I mentioned.
Yeah, so you can see registrars was a theme in here, and just kind of going back to the one you mentioned about the fee payment in the case of a three-member panel. So for those who aren't familiar, when a complainant files the case, they are required to pay a filing fee, and if a respondent elects for a three-member panel, they then pay their half of the three-member panel fee, and the complainant has to pay a supplemental fee. So in the case of WIPO, that means from the $1,500 filing fee, the respondent pays $2,000, and then the complainant has to pay an additional $500 to cover the three-member cost versus the one-member cost. Three-member panels are still relatively rare in the grand scheme of things, and even rarer, I can think of personally maybe 3 or 4 cases over all of the years I've been doing this where um, uh, uh, we as a provider have to chase a complainant to cover the additional $500. And that puts us sometimes in a slightly awkward spot, and the respondent is wondering what's going on. So we thought some clarity around that, frankly, would be welcome. Going to the registrars, there's a couple of topics that come up. One is ICANN's role in compliance. So sometimes when a case runs its course, it's the registrar that actually facilitates the implementation in that. And on a few occasions, we've seen where a registrar might not have a process in place to actually manage that because they might be a smaller registrar who's not familiar with the UDRP. Obviously, with the bigger players, they have processes and teams in place to manage this, and it all happens relatively smoothly. But for those registrars that aren't as familiar with the UDRP, we've seen some instances where a case runs its course, and then there's some complications with the implementation of the result of the decision. In a few cases, unfortunately, the domain name even then ends up in the hands of a third party who wasn't part of the original case, and the brand owner is faced with the choice of filing yet another case, even though they won the first case. So that was an area we thought, some simple guidance to registrars could really go a long way. Another area was the registrars assisting providers with providing notice of the dispute. So under the rules, there's a number of obligations that providers have in terms of providing notice. It's not always the case that 100% for certain that the person is receiving the information about the cases that's been filed against them. In the majority of the cases, the registrant doesn't bother to reply. And it's often said that that's an intentional choice because if they're a person, especially if you think of the kind of the prototypical repeat infringer, then they have no incentive to respond unless they just want to try to slow down the process. So there's certain obligations that the providers have to fulfill to achieve either actual notice or go through a series of steps to attempt to get that into the hands of the right person. But we thought, why don't we ask the registrar, who's the point of contact with the registrant themselves, help us out with that. And so that was one of our dedicated phone calls we had with registrars. And interestingly, some said they already do this, and some expressed some hesitation in doing that. But in any event, that was a recommendation of the project team And certainly from the provider perspective, I can say that that would be of great assistance. And another one that's come up a number of times over the years is some sort of a contribution from ICANN to the functioning of the UDRP. So for those that don't know, for every domain name registration, ICANN takes a small portion from both the registry and from the registrar. I think it's 43 cents total, if I'm not mistaken. But the question was whether a very small portion of that could go to help offset the running of the UDRP. And obviously, that can take different forms. That could be educating parties, that can be helping to offset the fees. In some CCTLTs, for example, they provide a discount to complainants that are small businesses or that sort of thing. The precise details, can be worked out, but the idea was, couldn't this go to help offset some of the functioning of the UDRP as is done in other CCTLD spaces? So I would say those are kind of the top ones for me, really, that the kind of the core being around how registrars help the UDRP function. And I think there it's worth bearing in mind that the reason the UDRP exists in the first place is because before it existed, then brand owners were going directly to the registration authorities to ask them to deal with these disputes. And since the UDRP came along, the registries and registrars have been able to effectively outsource that compliance function to UDRP providers and brand owners and registrants. And they have to obviously implement the result and do a few things along the way. But on the whole, it's if I may say, provided great value for money for them over the years. And so we thought it was a fair question to ask whether that ought to be revisited.
Yes, thank you. So just briefly, a couple other ones. I'll just highlight mediation. The project team looked at this upside and down, and mediation is something that sounds very attractive, a great way of resolving disputes. But at the end of the day, it's not something that the project team felt would be a benefit if it were to be mandatory and just add an extra layer of costs, etc. When in most cases, the respondent doesn't have a defensible case because it's a cyber squatter. By and large, I think the statistics on something like 95%. But voluntary mediation, something that's possible to consider. The going to tier 2, these are more controversial issues that we weren't able to reach agreement on, but as Brian and I indicated, agreement may still be possible. An appeals layer was something that was widely attractive as a general concept to the project team. It's a piece that's missing from the UDRP from one perspective, in that the only recourse after a UDRP is to go to court, and court is very expensive and much more time consuming. And so it would be nice to have an appeals layer, but the mechanics of making it work weren't that easy to reach agreement on. For example, are the decisions binding? Is it appeals from one 3-member panel to another 3-member panel? And does that make sense? Who gets to select who is on the appeals panel roster if there is an independent roster? And what about if a complainant or respondent uses the appeal procedure just to delay proceedings or to bring proceedings multiple times? That's something that needs to be avoided. We found some solutions to many of these. We weren't able to reach agreement. Oh, am I unstable?
You're back.
I'm back.
You're back.
Well, you missed everything brilliant I had to say, perhaps.
It's just the
Okay. All right. Well, listen, that's the appeals layer. Changing ante, or this is a perpetual thing that comes up, and there's at least 2 sides to this argument, possibly more. But and this is an area where many people are very much for it. Very many people are against it. Some people say that it wouldn't really make much of a difference. Other people say it could allow certain kinds of cases to proceed that previously weren't able to reach agreement, but there's some potential for finding some solutions to that. Expedited or summary procedure. Brian, I know you've paid a lot of attention to this issue over the years. If you care to say a few words about that, and then we'll, in the last 10 minutes or so, we'll see if there's any questions.
Yeah, I think this, like the question of appeals, was one that had a lot of initial attractiveness to the project team. Um, you know, as I mentioned earlier, the problem of cyber squatting is often described as the whack-a-mole problem. And so both with the expedited or summary process and the remedy of true cancellation that you see on the screen there, I think those were two that the group widely agreed had merit. But when we tried to see how that would work in practice, we hit a few stumbling blocks. And I think, I said earlier, if we had had more time, I suspect we might have been able to nail these down, but that wasn't possible. And we thought, let's get the report out and get feedback from people and see where that takes us. But largely the idea was, especially nowadays, we see more and more cases where there's basically criminal behavior alleged in the complaint. So that takes the form of phishing or fake invoices and that sort of thing. And I do think it's important to stress that the UDRP can be used to reclaim domain names that are subject to those types of abuses. But there's obviously other ways that are quicker and cheaper to do that. Brand owners can go directly to the registrar. They can file a complaint through a tool called NetBeacon and get those taken down much more quickly than is possible under the UDRP, because there are strict timelines under the UDRP. There's, for example, a time allotted for a respondent to lodge a defense, and of course, that's important to keep that, because you can't shortcut that in case the person wants to submit a response. And you're making kind of a value judgment that it's a phishing or criminal type of a case. But anyways, the point was, shouldn't it be possible to address those types of cases much more quickly if the brand owner is unable to get a successful resolution directly with the registrar or another venue? And again, I think this is a topic that had a lot of attractiveness amongst the project team. But when we tried to sort of land the plane, we weren't able to do that in the time we had. And same with the cancellation. Again, going back to that whack-a-mole question, some brand owners have quite large portfolios of domain names that are purely defensive registrations. I know personally some brand owners who have domain name portfolios on the order of tens of thousands that are purely defensive, and they're wildly disproportionate to the ones that the brands are actively using. And so the question was whether they should have to continue to pay the registration fees to the registry and registrar and ICANN for those domain names, or whether there ought to be a process to kind of park those to the side. And of course, it was important that if there was a third party who came along later and wanted to use that, then a process to unlock that should be created. But again, this was one where in the time that we had, then it wasn't possible to pull that together.
Yeah, the true cancellation was very interesting to me because, cancellation is a remedy under the UDRP now. But what it means is you cancel a domain, the name is canceled by the panel, it goes back into circulation. And so therefore it's a remedy that's seldom requested by complainants. So there ought to be a better way of doing it. But what if you do a true cancellation so it doesn't go back into circulation and doesn't get used, as Brian mentioned, it gets complicated because it could be a third party that has a valid reason forever prohibited from getting it unless there was a structure to enable that to be pulled out of cancellation. Panelist appointment, accreditation, quality. This is something that was debated, didn't reach agreement with the group. For example, there was an issue whether panelists should also be allowed to be advocates. And there was issues about what do you do when there's bad panelists, and are there standards across the board. So this is something that we weren't able to reach agreement on, but was a hotly deliberated upon topic. We have very few minutes left. I'm going to stop sharing my screen. And Camila, were there any questions that you're able to easily pull out for Brian and I that we could quickly try to address in the time we have left?
Yeah, not much time, but Todd asked a question, Todd Ryan, and you're allowed to talk, Todd, if you can ask your question live, and Brian and Zach can address it.
Fantastic. Thank you. And thanks for the webinar. For those interested in the topic, really happy that you put this on. Um, my question is, have you considered increasing the filing fee?
Can I ask Todd if you can maybe unpack that a little bit? Because certainly the topic did come up, and it came up, I recall in one particular instance in the context of, I mentioned earlier the idea of expedited or summary for, phishing or fraud type cases. But some brand owners said, look, we'd like an expedited process, irrespective of whether there's that criminal type behavior. They might have different reasons for wanting that case to be resolved quickly. Maybe they have a product they want to launch or something along those lines. And the reaction from the panelists was that would probably require additional fees because you're effectively asking a panelist to drop everything and render a decision in short order. But I wonder if you had maybe a specific use case in mind or kind of a general thrust behind the question.
Sure. And Brian, thanks for that. I think that's a good point, that it can certainly benefit a complainant by requesting something to be sped up, like you just mentioned. But I was thinking from another perspective as preventing these, say, bad faith claims, because now we're seeing a lot of valuable domain names that are being subject of a UDRP, and it's only $1,500 to file the claim, and it's been that price for some time. And I don't know, I think since the beginning. And it's just not a lot to prevent someone from trying to take a name. But I do like that the balance there, that if a fee was increased, that it can benefit the complainant in some cases, but it also would prevent, say, bad faith claims. So that was my perspective on it. My intention was, I think it would prevent these, fraudulent type of claims, people wanting to take valuable domains for giving, just under a $1,500 shot at taking it away.
Yeah, I can say, from the provider perspective, that's certainly a question that's come up over the years, and we've had, as I think will not surprise you, on the other side of that equation, particularly in light of the kind of the whack-a-mole problem and the fact that some brand owners have quite large portfolios of defensive registrations. We've received requests from brand owners to actually lower the fees. And so we've been really, as the provider at least, caught in the middle on that question. In terms of the notion of disincentivizing bad faith filings, certainly, as Zach mentioned, we looked at the idea of penalties for cases of attempted reverse domain name hijacking. And I can say, even in cases where there's a respondent default over the years, then panelists have found RDNH where they felt a brand owner was overreaching. So I know it's probably not a precise answer to your question about disincentivizing bad actors on one side of the equation, but I think on the whole there's a check built into the system where the panelists do look at each case irrespective of whether there's a response filed or not, and that was certainly a question that came up. There was a question in the chat about whether, what would it mean if there's a default? Would that be a fork in the road? Whether there should be a panel appointed that could impact the timelines, the costs, etc. Again, that was a topic that had a lot of discussion. But in the end, it was felt that the status quo was sort of the path of least resistance on that one.
All right, thank you, Todd. I'll just try to go through, a few of the chat comments. So yeah, that relates to what Michelle Brownlee had said, that she had a suggestion for default judgments. One of the considerations, as Brian mentioned, however, was that even when there's no response, some panels have found reverse domain name hijacking even with no response, and so there may need to be some checks and balances to prevent just pure default judgments. And if you read the report, there's some suggested approaches that we haven't reached agreement on, but that's something we certainly look for input on. Enrique asks, his question is, what is the following steps for the review? Well, right now we're in a delayed period where GNSO Council has delayed the review of the of UDRP for another 6 months, but we're hoping that GNSO Council will see that there's a practical and clear approach for the GNSO Council take here with the bifurcated approach and efficient and streamlined chartering that we're suggesting. Another one, Steve Levy, he mentions the enhanced notice for registrants, which is basically an additional notice method Brian touched upon in his remarks, which is that, registrar can notify their own client, because registrants sometimes see an email from an organization, another country they never heard of, and with an attachment PDF, and they see, my gosh, I better not click on that. But that's the notice of proceeding. Doesn't, probably doesn't happen a lot, because many of these complaints, they get it and they have nothing to respond with. But on the other hand, it does affect some registrant response, perhaps, and there is an easy fix to this. With registrars buying in cooperation to that. And I'll just also mention, Steve and George Chavansky and Nat and I worked on these issues for a couple years as well, and thank you for that. And Jeff has mentioned he wish he could say the council's paying attention, but unless you submit the final report to him, they will likely not pay attention. Brian, any remarks on that?
Yeah, that it's certainly I can say that the council leadership and ICANN are aware of the work that we're undertaking, as is the governmental advisory committee. The topic has been discussed a number of times over the years at ICANN meetings. In fact, the ICANN bylaws themselves call for obviously not a specific process has been undertaken here, but if you look at the first process undertaken by WIPO that led to the UDRP in the first place, then the ICANN bylaws actually call for the GNSO Council to look to outside organizations with subject matter expertise in its policy making process. So we've been doing, I can say, our level best to make sure that all of the parts of the ICANN community, the governmental advisory committee, the ICANN organization, the board of directors, the GNSO Council and leadership are aware of our work, and I think they are certainly, maybe not every single participant in the ICANN community is fully aware of that, but we've certainly done our level best up to this point to raise awareness, and we'll continue to do so when we get to the final report, and hopefully that proves useful in ICANN's policy deliberations from the chartering on through to any policy work itself.
Thank you. So Camila has put into the chat once again the link for feedback. Brian and I are asking you for your feedback. The kind of feedback we'd like isn't just about the particular policies and your recommendations and your particular positions on those, which we'd like to receive too, but also support generally for the approach that we're recommending, which is a highly focused, do no harm, efficient commencement of phase 2. So, if you just write a line or two about that, send in us feedback, we'd love to hear that, plus all of your substantive comments. Please read the report. It's an excellent product of the combined efforts of the 16 experts and in consultation with 23 other outside experts, but we also like to hear from you as well. Brian?
Yeah, I would really just echo that. We would welcome support for the recommendations, especially support for the process we've undertaken for the process path forward at ICANN. And to the extent there are specific comments on either the items that we've identified in the report or something we might have missed, I would really stress the more practical people could be, the better. That I think would really help the project team to consider the issues. And as I mentioned earlier, we did receive one comment on a particular topic that was actually covered in quite some detail in the report. So if you did have a particular topic that's on your mind, I would encourage you to look at the report and see what the project team considered in its deliberations and why it landed on the particular recommendation. And if you felt that it should go in a different direction, really think, practically speaking, what it would look like in practice for the parties to the process, for the registrar, for the providers, and think, of potential unintended consequences in deploying an idea in practice. Because certainly, there are a lot of good ideas, but they sometimes have ripple effects, and we really want it to be mindful of a holistic approach, and as we've said, through and through, to not upset the good balance that's been achieved over all these years.
Thank you to both of you. What a packed hour, a little bit over the hour. Thank you so much, Zak, Brian, and thank you to the entire project team. Before I say goodbye to everybody, the ICA will be hosting a Levine lecture in July. I'll post a link in the window, and we hope all of you UDRP enthusiasts can join us there. We do have quite a few more questions or comments in the window, but I don't think we'll be able to address them. Perhaps you can email them to us, and we can pass them on to Zak and Brian, and they can address them afterwards. So thank you again, everyone. Take care, and thanks for joining us. See you on the next one.